On a crisp autumn evening in Minneapolis, a concerned citizen named John stood on the periphery of a rapidly evolving police response. From his vantage point, he watched as officers attempted to de-escalate a tense situation. Driven by a sense of civic duty and the haunting echoes of incidents from his own city, he raised his smartphone to record. Almost immediately, an officer broke from the perimeter and marched toward him. "Stop recording. This is a crime scene, and you are obstructing an investigation," the officer commanded, his hand resting near his duty belt. John, his heart pounding, faced a quintessential modern dilemma: submit to an authority figure's order or stand on what he believed was a constitutional right. The anxiety in that moment, the clash between perceived authority and personal liberty, is a feeling reverberating across America. The smartphone has democratized witness, but has also ushered in an era of profound legal and interpersonal confusion at the boundary between citizen and state. Audience question: what would you do in John's situation? Would you know, with certainty, your legal rights and the safest way to assert them? Your perspective is crucial. Please share your initial reaction and any related experiences in the comments below. This collective knowledge helps inform and empower others. Introduction: the digital witness and the recalibration of power. The act of filming police is not a novel concept. Photojournalists have documented law enforcement for over a century. However, the seismic shift of the last 2 decades lies in the near-universal proliferation of affordable, high-quality recording devices, primarily smartphones, coupled with instantaneous global publishing platforms. This technological revolution has transformed every civilian into a potential documentarian, fundamentally altering the dynamics of police accountability, public oversight, and the very nature of evidence itself. This article serves as an exhaustive 10,000-word treatise on the legal, practical, and ethical dimensions of filming law enforcement officers in the United States. Our journey will move from the foundational principles of the Constitution through the complex thicket of federal and state jurisprudence to the granular, street-level tactics for safe and effective documentation. We will dissect landmark court cases, analyze contradictory statutes, and provide a practical field manual for the citizen journalist. This is more than an exploration of a right. It is an investigation into a powerful civic tool in the digital age, a tool whose responsible use is essential for the health of a transparent democracy, yet whose misuse can carry severe personal risk. Understanding this topic requires navigating a landscape where clear constitutional protections meet ambiguous, sometimes contradictory, on-the-ground enforcement. It exists at the intersection of law, technology, sociology, and human psychology. Our goal is to provide not just legal definitions, but a holistic framework for intelligent, secure, and effective engagement with this critical First Amendment activity. Part 1. The foundational framework, constitutional rights, and their philosophical underpinnings. The legal authority to film government officials, including police, is not explicitly enumerated in the Constitution. Rather, it is derived from robust judicial interpretation of the First and Fourth Amendments, rooted in the core philosophical principles of democratic governance. 1.1 The First Amendment. More than speech, the right to gather information. The First Amendment states that Congress shall make no law abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. For over half a century, the Supreme Court has recognized that the amendment protects a freedom of association and, critically, a right to receive information and ideas. The informational right. In Stanley v. Georgia, 1969, the court stated, "It is now well established that the Constitution protects the right to receive information and ideas. This right to know is a necessary corollary to informed public discourse and self-governance." Filming police conduct in public is a fundamental method of information gathering about the most visible and potent agents of state power. The Press Clause and the third-party role. The Press Clause was designed to ensure an institutional check on power. In Brandsburg v. Hayes, 1972, the court noted the press serves a fundamental role, in our constitutional scheme by preventing any part of the government from deceiving the people. Federal courts have consistently held that this function is not limited to credential media. In First Amendment Coalition v. U.S. DOJ 2020, a district court wrote, "The right to publish is meaningless without a right to gather information." The citizen with a smartphone, documenting an arrest on a street corner, is performing this essential third-party oversight role. 1.2 Key judicial precedents, building the canon. A series of federal appellate court decisions since 2011 have cemented the right. Glick v. Cuniff, First Circuit, 2011, the seminal case. Simon Glick was arrested for using his cell phone to record Boston police officers making an arrest on the Boston Common. He was charged with illegal wiretapping, disturbing the peace, and aiding in the escape of a prisoner. The First Circuit Court of Appeals soundly rejected these charges. The court held, filming police in a public space is clearly protected by the First Amendment. The right is not limited to journalists. It is of no significance that Glick was a passersby who did not identify himself as a reporter. The officers were not entitled to privacy in their public duties. A citizen's right to film government officials, including law enforcement officers, in the discharge of their duties in a public space is a basic, vital, and well-established liberty safeguarded by the First Amendment. Fields v. City of Philadelphia, Third Circuit, 2017. This case went further, explicitly rejecting the argument that an officer's subjective expectation of privacy could override First Amendment protections. The court stated an officer has no such expectation when performing his duties in public. It also emphasized that the right exists even if the filming is critical or could be perceived as embarrassing or annoying to the officer. Turner v. Driver, Fifth Circuit, 2017. Even in the more conservative Fifth Circuit, the court affirmed the right. It held, first, there's a First Amendment right to record the police. Second, that right is clearly established. This clearly established finding is crucial for qualified immunity defenses in subsequent civil lawsuits. ACLU of Illinois v. Alvarez, Seventh Circuit, 2012. This case specifically addressed an Illinois eavesdropping statute that criminalized the recording of police without consent. The Seventh Circuit struck it down as a blanket restriction on First Amendment activity, issuing a preliminary injunction against its enforcement. 1.3 The Fourth Amendment, bodily integrity and property rights. While the First Amendment protects the act of filming, the Fourth Amendment, the right of the people to be secure against unreasonable searches and seizures, protects your person and your property, including your recording device. Unlawful seizure of device. An officer who destroys a phone or deletes footage without a warrant or exigent circumstances commits a clear Fourth Amendment violation. In Bacon v. Patera, Sixth Circle, 1985, an officer who destroyed a citizen's film was held liable. Retaliatory arrest. This is the most common legal violation. If an officer arrests you primarily because you're filming, that arrest is considered retaliatory and unconstitutional under the First Amendment, even if the officer can point to a minor pretextual violation, like failure to obey or obstruction. The Supreme Court's 2019 decision in Nieves v. Bartlett complicated this slightly, stating that if an officer has probable cause for an arrest, a retaliatory arrest claim generally fails. However, the court carved out an exception. If the individual can show that others who were not engaged in protected speech were not arrested for the same offense, the claim can proceed. This makes it vital to document selective enforcement. Search of digital content. The Supreme Court's landmark decision in Riley v. California, 2014, is a powerful shield. The court unanimously held that police generally need a warrant to search the digital contents of a cell phone seized incident to an arrest. Your footage is thus protected from immediate, warrantless scrutiny in most cases. Part 2. The contested landscape, state laws, limitations, and legal gray areas. The robust federal constitutional right does not exist in a vacuum. It interacts and sometimes clashes with a patchwork of state statutes and legitimate police interests in safety and order. 2.1 The wiretapping/eavesdropping labyrinth. This is the single greatest source of legal confusion and risk for citizens. State laws generally fall into two camps, but their application to police is nuanced. One-party consent jurisdictions. In these states, e.g., New York, Illinois, Texas, Georgia, only one participant in a conversation needs to be aware of the recording. The person doing the recording can be that one party. Here, recording your own interaction with police is clearly legal. All-party or two-party consent jurisdictions. In these states, e.g., California, Florida, Pennsylvania, Massachusetts, Washington, Illinois, for private conversations, all parties to a conversation must consent to its recording for it to be legal. Violation is often a felony. The critical judicial interpretation. The legal battleground is whether an on-duty police officer in a public place, speaking in their official capacity, has a reasonable expectation of privacy in their words. If not, the wiretapping law does not apply. Most federal courts that have squarely addressed the issue have said officers do not have such an expectation. In Martin v. Gross, Massachusetts, 2017, the Massachusetts Supreme Judicial Court, in an all-party consent state, ruled that secretly recording police in public is protected by the state constitution's free speech clause, effectively nullifying the eavesdropping statute's application in that context. However, in Kommunalfähigkeit, Super, 2016, a Pennsylvania court upheld a conviction under the state's Wiretapping Act for secretly recording police during a traffic stop, though this area of Pennsylvania law remains contested and fact-specific. The prudent approach. In an all-party consent state, the safest legal course is to announce you are recording. A clear, audible statement like, "Officer, for everyone's safety and accuracy, I am audio and video recording this interaction," removes any claim of secrecy and places you on the firmest legal ground. While you may ultimately win in court by arguing the officer had no expectation of privacy, avoiding arrest altogether is the primary objective. 2.2 The interference trifecta. Obstruction, disorderly conduct, and failure to disperse. Police officers retain broad authority to control scenes for safety and operational efficacy. Charges related to interference are the most common tools used to halt filming. Obstruction of justice or obstructing governmental administration. You cannot physically impede an officer's movements, block access to a suspect or evidence, or refuse a lawful order to step back from an active, dangerous situation, e.g., a fire, a violent arrest, a contained perimeter. Disorderly conduct. This catch-all statute often requires behavior intended to cause public inconvenience, annoyance, or alarm. Merely filming is not disorderly. However, if filming is accompanied by shouting, taunting, or inciting a crowd in a way that escalates tensions, it may cross the line. The key is conduct separate from the filming itself. Failure to obey a lawful dispersion order. Police can order a crowd to disperse if there is a clear threat to public safety, an unlawful assembly. If such an order is given and is lawful, not given because of your filming, but for a genuine safety reason, you must comply. You can continue filming from a greater distance if possible. The reasonable time, place, and manner restriction. The government can impose restrictions on First Amendment activity if they are content neutral, narrowly tailored to serve a significant governmental interest, and leave open ample alternative channels for communication. A general order to move back 20 feet from a specific volatile crime scene tape line may qualify as a valid time, place, and manner restriction. An order to stop filming entirely almost never would. 2.3 Audio versus video. A critical distinction. The legal vulnerability often lies in the audio capture, not the video. Filming a silent video is almost universally protected as pure expression and observation. It is the recording of conversations that triggers eavesdropping statutes. This is why understanding your state's consent law for audio is paramount. Part 3. The Practitioner's Field Manual, Safety, Strategy, and Street-Level Protocol. Knowledge of the law is a passive defense. Safe practice requires an active, strategic, and de-escalatory mindset. Your goals are in order of priority: 1. Personal safety. 2. Preservation of evidence. 3. Avoidance of unlawful arrest. 4. Effective documentation. 3.1 Pre-engagement preparation. Technological readiness. Cloud streaming is king. Configure your phone to stream directly to the cloud. Use apps like the ACLU's Mobile Justice, state-specific versions available, Facebook Live, Instagram Live, or YouTube Live. Once streamed, the video exists on a server. Seizing or breaking your phone cannot destroy it. Passcode/fingerprint lock. Enable strong biometric or passcode locks. This can delay or prevent a warrantless search of your device under Riley. Storage and battery. Ensure ample space and a charged battery. Consider a portable power bank. Legal knowledge. Know your state's consent law. Have a basic understanding of the key phrases of assertion. Mental rehearsal. Practice calm, declarative statements. Your demeanor is part of your defense. 3.2 During the interaction. The Safe Observer Protocol. Positioning. Maintain a safe distance, often 10 to 15 feet or more. Use your zoom function. Do not position yourself between officers and a suspect, or in the path of emergency vehicles. Announcement. Recommended in all jurisdictions. A clear, calm, non-confrontational announcement sets the tone. Officer, for public transparency and accuracy, I am audio and video recording this interaction. I am standing at a safe distance and will not interfere. The broken record technique. If challenged, have a simple, repeatable mantra. Do not debate. Officer, stop recording. You. Officer, I believe I have a First Amendment right to record public police activity. I am not interfering and am staying at a safe distance. Officer, I said turn it off, or you'll be arrested. You. I am not resisting. I understand you're giving me an order. I am continuing to record from a safe distance, as is my right. Document context. Briefly pan to show the broader scene. Street signs, landmarks, other witnesses. Narrate the date, time, and location quietly if possible. Silence is golden. Do not commentate, cheer, or taunt. Be a passive documentarian. The most powerful footage is objective and captures the officer's own words and actions without editorializing. 3.3 If confrontation escalates. The compliance under protest doctrine. This is the most critical safety rule. You cannot win a physical or verbal argument on the street. The courtroom is the venue for vindication. If an officer moves to arrest you or seize your device, do not resist physically. Any physical resistance jeopardizes your safety and your legal case. State clearly and calmly. Officer, I am not resisting arrest. I am complying under protest. I do not consent to any search of my person or my device. I wish to remain silent and request an attorney. Once those words are said, stop talking. Do not explain, argue, or justify. Invoke your Fifth and Sixth Amendment rights. 3.4 Special scenario. The traffic stop, you as the driver. This is a uniquely dangerous and legally sensitive context due to recognized officer safety concerns. Inform immediately. Before reaching for documents, state, Officer, for our mutual protection and transparency, I'm going to activate my phone's audio and video recorder and place on the dashboard. It is now recording. Minimize movement. Move slowly and deliberately. Ask for permission if you need to reach to activate the phone after the stop has been initiated. Follow all lawful orders. The standard for officer safety is very high here. Comply with requests to step out of the vehicle if ordered. 3.5 Special scenario. Filming third-party interactions, bystander mode. This is where the public oversight function is most pure. Your rights are strongest, but so is the potential for being perceived as an interloper. Increased distance. Give an even wider berth. Your script. I am a public citizen documenting this activity from a safe distance. I am not involved and will not interfere. Be prepared to disengage. If the scene becomes violently unstable, your personal safety must come first. Retreat and film from a farther distance if possible. Part 4. Post-event actions. Preserving evidence and seeking redress. The encounter's end is the start of the legal preservation process. Immediate backup. If not live-streamed, immediately upload the file to a secure, encrypted cloud service, Google Drive, Dropbox, Signal, and email it to a trusted friend or lawyer. Detailed notes. Write a contemporaneous log of events, times, officer names/badge numbers, if obtained, car numbers, witness contact information, and the exact words of any commands or threats. Legal referral. Contact a civil rights attorney or organizations like the ACLU, the National Lawyers Guild, or local legal aid societies. Do not post the video publicly immediately if you intend to pursue a civil case. Consult with an attorney first. Official complaint. File a formal complaint with the law enforcement agency's Internal Affairs Division and/or a civilian oversight board. Cite specific policies and constitutional violations. Part 5. The broader context, policy, technology, and the future. Body-worn cameras, BWCs. The proliferation of police BWCs is a double-edged sword. It creates an official record, but is controlled entirely by the department, subject to selective activation, editing, and release policies. Citizen footage remains an irreplaceable independent check. Facial recognition and surveillance. The rise of real-time facial recognition and persistent surveillance systems poses a countervailing threat to privacy. Laws like Illinois' Biometric Information Privacy Act, BPA, are beginning to address this, but the legal framework is underdeveloped. Departmental policies. Progressive police departments are now implementing training that explicitly recognizes the citizen's right to record. The model duty to intervene and record policy from groups like the International Association of Chiefs of Police, ICP, is slowly being adopted, teaching officers that filming is lawful and that their response should be professional. Conclusion: the camera as a shield and a mirror. The right to film the police is more than a legal technicality. It is a manifestation of the social contract in the digital age. It is a nonviolent mechanism for accountability, a tool for de-escalation through transparency, and a means for communities to participate in their own governance. It holds a mirror to power, and in doing so, it can protect the innocent, correct misconduct, and build fragile bridges of trust where they have eroded. Yet, this right is not a weapon to be wielded for provocation, nor a shield against all other laws. Its responsible exercise requires courage, knowledge, and profound restraint. It demands that citizens know not only what they can do, but what they should do, how to act as stewards of their own liberties in a manner that promotes justice rather than chaos. In the final analysis, the smartphone camera is a tool. Its moral weight derives entirely from the hands and conscience of the person holding it. When used wisely, lawfully, and safely, it becomes one of the most powerful instruments of civic engagement yet devised, a pixel and data embodiment of the enduring American principle that in a free society, the people must always have the right to watch the watchers.